Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to turn our attention to the Garden State. This past week, New Jersey became the 13th state in the nation to enact a comprehensive data protection law. The new law goes beyond breach notification to encompass standards for the collection, sharing, and disposal of data. The legislation coming out of Trenton seeks to crack down on the use of personal information by so-called data brokers, requiring businesses who trade in such information to provide an opt-out mechanism to consumers that is clear and conspicuous. Consumers will also have a right to know what data is being held on them so that they can correct or delete any inaccurate information. And companies must limit the collection of personal data to what is relevant to the conduct of their business, and they're required to notify consumers of the specific purposes for which their data is being processed. Importantly, this includes consumer financial data. The law applies to organizations that hold data on at least 100,000 individuals, and for those that generate revenue from such data, the threshold for those businesses is lowered to 25,000 persons. Data that is processed solely for the purpose of completing a business transaction is exempt from the new requirements. But what's perhaps most striking about this new law is the Universal Opt-out Mechanism, or UOOM. This allows consumers to opt out of not just targeted ads and the sale of their data, but user profiling as well. And for minors, the law goes one step further. Businesses cannot collect personal data on children between the ages of 13 and 16 unless they affirmatively opt in to the collection of such data. So what does all of this mean for your company? Well, if you do business in New Jersey and meet the record count threshold, you should review your current data collection practices with Privacy Counsel to determine what steps you will need to take to remain in compliance with this new law. Need a referral to qualified Privacy Counsel? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com. Companies should also expect underwriters to scrutinize data collection practices even more closely at their upcoming cyber insurance renewals. And please note that if you don't conduct business in New Jersey, this trend is going nationwide. A similar bill just passed both houses of the New Hampshire legislature, and at the time of this recording awaits the governor's signature. If the bill is signed into law, New Hampshire will become the 14th state with its own data protection statute, making passage of a federal law even more challenging. This patchwork of data privacy laws really puts the onus on businesses to make sure that they are getting competent legal advice. Beyond that, it's time to brush up on your coverage for regulatory proceedings. As I've said before, cyber insurance policies are not all created equal. The language is not standardized, and there's a wide range of variation in policy forms, as well as the underwriting appetites of various carriers. You're going to want to look at the triggers for coverage, as well as at any exclusions for wrongful collection of data. Equally important is the wording around the insurability of fines and penalties. Sometimes you just have to know what questions to ask in order to obtain best-in-class policy wording. Now, if your insurance broker isn't having these conversations with you, maybe it's time that you discover the more rewarding way to manage risk. Thanks for watching.